様お待たせいたしました。それでは引き続きインドのプレゼンテーションを行っていただきます。まず模擬裁判の配役をご紹介させていただきます。原告代理人役アーナンド&アーナンド法律事務所プラビン・アーナンド弁護士、被告代理人役知的財産法律事務所インテレクチュアルアドボケアヘマント・シン弁護士、シン&シン法律事務所サヤ・チョーダリー・カプール弁護士、専門家証人役アーナンド&ハーナンド法律事務所ラジブ・バトナガー弁理士です。失礼いたしました。そして裁判長役はデリー高等裁判所プラティバ・シン裁判官です。ご起立願います。
We start today's mock trial with the status of patent litigation in India. As you all know, in India we have 3 levels of courts: district courts, high courts and Supreme Court. There are more than 600 district courts in the country, and patent cases can be filed in the district court in India. The metropolitan cities have high courts which have original jurisdiction, like Delhi, Mumbai, Calcutta, Chennai, and one of the hilly areas. However, what is interesting is, in a patent infringement action, if the defendant files a counterclaim to seek revocation of the patent, then the case gets transferred to the High Court automatically. So because of that, almost all the patent decisions in the country are dealt with by the high courts. Almost all intellectual property cases which are valued above $4,000 are commercial disputes. India enacted a Commercial Courts Act in 2015. This act provides for very strict timelines in terms of pleadings, evidence, and judgment, etc. It also provides for payment of heavy costs. There is a streamlined process which has been put in place. We have a case management hearing under this act, and the court has the power to pass summary judgment. So in a large number of intellectual property matters, we find summary judgments being passed, especially when the plaintiff does not insist on damages as one of the relief. This is the timeline fixed by the Commercial Courts Act. So from the filing of the suit, within 120 days, the defense has to be filed. And after that, there is a process of admission and denial, which is called the exchange of documents and inspection. The first case management hearing takes place after the pleadings are completed and documents are exhibited. In the first case management hearing, the judge hears brief summary arguments on behalf of the plaintiff and the defendant, frames issues in the matter. Thereafter, the witnesses lead their evidence. Usually, witnesses' evidence can be recorded even by court-appointed local commissioners, because sometimes courts do not have the time to record evidence in court. So local commissioners record the evidence, and then the oral arguments take place. Upon oral arguments concluding within 90 days, the judgment has to be pronounced. In a patent case, the defendant can challenge the validity of a patent by filing a counterclaim. However, if the defendant does not wish to seek revocation, the defendant always has the option of raising all the grounds of invalidity as defenses to infringement action itself. That's under Section 107 of the Act. The various milestones in a litigation I've already mentioned in the timeline. Now, in the first case management hearing, as I said, the issues are framed by the court. In the case of a patent, the onus of infringement usually is on the plaintiff. However, in the case of a process patent, if the process of the defendant is not known and the product appears identical, then the onus shifts upon the defendant. That is section 104A. Then there is a schedule fixed for appointment of the local commissioner, list of witnesses, etc. And one important feature is that the Delhi High Court has recently amended its original side rules, and it recognizes concepts such as confidentiality club and hot tub procedures, which were mentioned by the Australian delegation. There are several matters where confidentiality clubs have been appointed for exchange of documents. And thereafter, under section 115, the court has the option of appointing a scientific advisor to assist the court. The usual relief in a patent matter is, of course, injunction. Then the onus to prove damages is on the plaintiff. Usually it is a percentage of the product itself, of the sale value of the product. It's usual in patent matters, especially in pharmaceutical and in electronic and telecommunication matters, for courts to grant millions of dollars of damages. It has happened, and there have been large amount of settlements where $20–30 million has even been paid as royalties. Two important features in damages. Section 111 provides that if on the date of infringement the defendant was not aware of the grant of the patent, if he is able to prove that, then the court cannot grant past damages. It can only grant future damages after filing of the suit. However, in general, the plaintiff is entitled to damages under section 11A(7) of the Patent Act from the date of publication of the patent, even prior to grant. So therefore, from the day when the patent is published, though a plaintiff cannot file a suit, if the patent is thereafter granted and he has put a defendant to notice, he can always claim damages from the date of publication of the patent. This is the overview of patent litigation, which I wish to give you all. Coming to the status of this mock trial, there are 4 scenes that we have planned for you. The first scene is that the pleadings have been completed, the documents have been exhibited between the parties. The first scene will be the case management hearing, where the plaintiffs and the defendants' counsel will make their opening submissions. Then parties would be permitted to file their affidavits in evidence that would be taken for granted in this mock trial. Scene 2 will be the evidence of an expert witness whom the plaintiff has produced today. Scene 3 will be closing arguments by the parties, and the pronouncement of judgment will be scene 4. We now move to the first scene of the mock trial today. As you're all aware, the pleadings have been completed in the matter. The defendant has chosen not to file a counterclaim because that's what the facts state. However, invalidity of the suit patent has been raised as a defense in the written statement, which is permitted under Indian law. Admission and denial of documents has been conducted. All the admitted documents would be read in evidence without need of any further proof, and the matter is listed for framing of issues. I would now call upon the counsel for the plaintiff, Mr. Anand, to make his opening submissions. You can bring it back.
May it please my lady. I'm Praveen Anand, counsel for Pony Corporation in this patent infringement lawsuit. The facts have been elaborately enumerated in the previous sessions today, and therefore I will come straight to the key issues. First, what is the proper construction of patent number 201-90925, and specifically two sub-questions: whether all features of the car navigation system need to reside in the car, and second, the proper interpretation to be given to the terms first memory and second memory means. And the second aspect, what is the impact or effect of the prosecution history on claim construction? As your ladyship knows, a principle well established that claim construction is ultimately a question of law, but it may involve factual disputes, underlying factual disputes, particularly, and I cite Teva versus Sandoz, the US Supreme Court decision, which is followed in India, particularly when technical words or phrases are used, and the passage is given there, but I'll read, which could help to establish a usage of the trade or locality. Two admitted facts in the case which are important. First, the plaintiff has a patent for a car navigation system, and the patent is not it's a method. It's a method claim, and the validity of the patent is not in question. And second, what the defendants are doing is admitted and not in dispute. What they're doing is admitted. The question is, what they're doing, is it covered by the plaintiff's claims? What is the inventive concept of the plaintiff's patent? And the inventive concept can be culled out from the patent specification, and particularly the portions marked objectives and background, or what are known as conventional art. And the two main objectives are: first, it's a method which does not require a user to have previous locational knowledge of a place of interest. And second, the operation of display which was very complex, has been highly simplified. These are the two stated objectives, and therefore the inventive concept. It is a cardinal rule of claim construction in Indian law that the claim must be interpreted on its own language. And if it is clear, then resort cannot be had to either the complete specification or to any other document, anterior or post or later. Resort cannot be had to any such document to regulate the scope, reduce, narrow the scope of the claim, or for that matter, even to enlarge the scope of the claim. The claims, for example, have got two features. First, the claim is a means cum function claim. A means cum function claim in which the word memory, which is either a noun or a verb, has been used as a verb. It's important that this is noticed. And second, the word means is a nonce word, N-O-N-C-E. And nonce words are known in patent language when they're written into claims not to have any particular structure. And I cite here Williamson versus Citrix, the case of Williamson versus Citrix,
Mr.
where the
Anand,
word...
has nonce words been used in any Indian law till now?
Yes, the Patent Office manual recognizes means cum function claims, and the Phillips versus Bhagirathi matter, nonce words were discussed, written in the written note of arguments, and spoken about.
All right.
Therefore, nonce words can have any structure. For example, the example given in the Patent Office manual is that of a metal spring in the claim, but in the embodiment, a copper spring was used. But that does not mean that the claim does not cover a steel spring or a titanium spring. I now cite the WIPO patent drafting manual for embodiments. Embodiments are only illustrative of the invention. And the WIPO manual gives an example in the second part of a cup with a handle, which could include a clay cup or a plastic cup. And my Lord's decision in Communication Components versus ACE, delivered only on the 12th of July this year, recognizes that claims are broader than even preferred embodiments in the patent. The defendants have copied the core concept, the terminal within the vehicle with an input and output, the storage of spot data, the storage of memo data, and the display of a map. And this they clearly infringe. The terminal and the screen have to be inside the vehicle. But the first and the secondary memory can be outside, inside, on a server, on the cloud, anywhere. Finally, the prosecution history. The prosecution history cannot alter the scope of the claims unless there is some sort of estoppel. And here, what was said to the patent office was the need for a battery, not the location of a battery, to protect the RAM. And the battery in this case is also available in the D server. That's all.
Would counsel for the defendant make the opening arguments?
May I please, Your Ladyship? I'm Hemant Singh and I represent the defendant here. Look, the first point which I would like to make here is that if we look at the claims are surely not very clear. There is an ambiguity in the claim. The claim talks about the first memory mean, the second memory mean, the exchange of the data, the storage of the data. It's more in the nature of a process claim. It's not a product claim. And therefore, it's very important to understand as to how the method claim is enabled. And for that, there is no guidance in the claim. You have to look at the specification, particularly. Now, as far as the preamble of the claim is concerned, if you look at the preamble, Your Ladyship will appreciate that it very clearly says a method to control the navigation system. It's not about navigation system, it's about controlling the navigation system. The inventor, at the date of the state of the art, was looking to invent and provide a navigation system which is cost effective, a navigation system which is convenient. And therefore, he provided a navigation system which is a composite unit. There is no reason as to why the inventor did not include or have any reference about the wireless connectivity, about various components which he has described in the specification. The wireless connectivity existed. They were well known. In fact, they were the state of the art. We had moved from the wire to wireless technology.
Mr. Singh, is the specification frozen in point of time? Is that your argument?
It is not frozen, Your Ladyship, but what is important is that there is a conscious exclusion of wireless navigation system in the specification, and I ask myself that question as to why it has been excluded. And the only answer which I get is to provide and to ensure that navigation system remains controlled to the user. And how does it remain controlled? Because he doesn't depend on a wireless connectivity. He has the display panel, he has the CD-ROM, the GPS sensors, the RAM, everything installed in the vehicle. And that's why the purpose and the objective behind the invention has to be kept in the mind while construing the claim. Therefore, my first submission there is, this is a case where not literal construction, but the purposive construction that we need to apply to the claims. I will go to the second point, that we are reading the claims, Your Ladyship, in isolation. But I rely upon the judgment of our Honorable Supreme Court in the Vishwanath Prasad, reported as 1979 to SCC 511, that you have to first read the specification before you go to the claim. And you have to read the claim and the specification together. And third thing is, our patentee cannot get more than what he desires in the patent. Therefore, we cannot be reading a claim post facto, as if it has to be read what today it is. We have to see what the inventor intended to be. I would therefore say that when we read the claim and the specification together, it's a composite unit. There is no reason as to why there is no reference to the wireless network. Number 3, Milord, if I may say, there is a statutory requirement on a patentee to make a disclosure of the enablement of the invention. In fact, if the enabling disclosure is something which is not clear, it's a ground for cancellation, it's a ground for invalidation of the patent. That enabling disclosure is limited in its explanation and description and the drawings and the illustrations to a composite navigation system. Therefore, today, is it unfair or fair? That's a question I ask myself. For a patentee to say that though I have not included in my specification an enabling disclosure which is a guidance about the use of wireless navigation system, you must read that. I would say, my lord, if that has to be read as it is, this claim is surely invalid. In particular, Your Ladyship, I rely upon 3 rules of claim construction. First, I rely upon the rule of purposive construction, where we have to construct the claim so as to give effect to its objective and to give effect to what the purpose of the claim is. If you have a navigation system which dependent on a wireless connectivity, we all can get lost because when you're driving, you may have or you may not have a wireless connectivity. But if you have a system which is installed in the vehicle, you don't have to bother about wireless
So are you saying your client's product can't work without internet connectivity?
Yes, my product is very different. My product is in fact different, and it caters to a different need. It caters to so we are talking about, Your Ladyship, 2 different products. We are talking about a product of a navigation system which is focused on providing a convenient navigation system, and our product is about a navigation system which is got no limitation in terms of coverage, territorial coverage. So it's a choice which is given to the user to choose between the convenience and the coverage. The products are different. I also rely upon the claim construction that a claim must be construed in a manner to preserve the validity of the claim. If we read the claim the way the plaintiff is reading it, which is very, very broad, then this claim needs to be invalidated. The only way we can preserve the validity is to read it as it is described in the specification and as it was represented while obtaining the patent. I also rely upon the principle of approbate and reprobate. The plaintiff today cannot be permitted to say, I have obtained the patent on the basis of a representation that my navigation system is installed in the vehicle, but when it comes to infringement, it says it is not limited to a navigation system installed in the vehicle. I therefore plead that there is no infringement.
The counsels for the parties have been heard, and after hearing the parties, the court has framed the following issues. The first issue is whether the court has jurisdiction to decide the issues in the suit, because the defendant has raised it in the written statement. Secondly, whether the plaintiff is the registered owner of the suit patent. Third, whether the defendant is infringing the patent. Fourth, whether the suit patent is invalid. Fifth, whether the plaintiff is entitled to seek an injunction, and whether the plaintiff is entitled to damages. In this mock trial, we are restricting ourselves to issue number 3 and 5, because insofar as jurisdiction and other issues are concerned, they would be decided on the basis of the pleadings of the parties. Invalidity is not going to be decided in the present proceeding. Would the plaintiff like to lead any evidence in this matter?
My lady, the plaintiff will like to examine a independent technical witness, Mr. Rajiv Bhatnagar.
Please give him oath.
Mr. Bhatnagar, please state your name, your father's name, and your age.
My name is Rajiv Bhatnagar, son of late Mr. S.P. Bhatnagar, my age is 67 years.
Please state after me, whatever I shall state shall be the truth, nothing but the truth, so help me God.
Whatever I will say shall be the truth, nothing but the truth, so help me God.
Mr. Bhatnagar, what are your educational qualifications and experience?
I am a B.Tech in Electronics and Controls from IIT Kanpur, and I have 45 years experience in research and development in electronics, including navigation systems.
Mr. Bhatnagar, would you like to sit down and answer? There's no problem.
Would you consider yourself an expert in the field?
Yes, I would.
And do you have any document which you'd like to place?
Yes, I have an affidavit in which I provide evidence of definition of memory.
It's a dictionary
It's
download?
a dictionary download.
Is it supported by an affidavit under Section 65B
Yes, it is.
of the Evidence Act?
Have you served a copy of this on the other side?
My lords, it being a dictionary, I thought it's a reference. And
Please
therefore-
provide a copy during the course of proceedings.
Okay.
It's okay. It's taken.
Please.
In the field of car navigation systems, who would you consider to be a person of ordinary skill in the art?
A person with a degree in electronics and communication systems, with preferably a few years of experience in navigation systems.
And in the year 2002, was cloud computing known?
Yes, it was known. It had been conceived in the 1960s, and with the 1990s onwards, it was in use.
And remote data storage, was that known?
Yes, that was known even earlier than 1990.
And were there any companies known to you in 2002 that would indulge in these, that would provide these services?
Yes, Amazon Web Services comes to mind.
And would the inventors of the patent have known, according to your expert opinion, that memory can be decentralized or kept at a remote location or even on the cloud?
Yes, I believe they would certainly have known that fact.
And would it be reasonable to assume that the inventors must have intended the decentralized concept when it came to the first memory means and the second memory means?
I believe they would have definitely considered that as being encompassed in the patent.
Cost-wise, what would be the relative cost of a server solution versus a client solution?
Server solutions are generally cheaper when averaged out over individual user because the costs are shared across a large number of users.
And is there anything in the patent document, which presumably you have read, which would suggest to a person of ordinary skill in the art that the first and the second memories can be located remotely or on the cloud?
The general knowledge of the person reading the document would certainly bring that to his mind, though the embodiment may be limited to what was implemented.
So that would be his common general knowledge?
Certainly.
And in September 2002 or nearabouts, were communication devices or communication means between devices known in the trade?
Yes, they were known much earlier than that, and there were products such as modems which were utilized for such purposes.
That's all, my lord.
Would the defendant's counsel like to cross-examine?
Yes, Your Lordship. Mr. Bhatnagar, have you had any interaction or discussion with the inventor for the subject invention?
No, I have not.
Now, taking into consideration the fact that the claimed invention is a method for control of a car navigation system, as a person skilled in the art, do you agree that the individual components and the features are imbibed in the method claim as well?
Yes, the features are imbibed in the method claim.
How are the individual components of the car navigation system connected to each other?
The person reading the patent document would know that the connection could be of various types, though a particular embodiment has been shown, but there could be many other connecting methods.
Is wireless embodiment disclosed or discussed in the complete specification?
Not explicitly, but by common general knowledge implicitly.
So would I be correct to say that the explicit disclosure is limited to use of buses or bus lines?
Yeah, that one embodiment is limited to bus lines, but that is only an embodiment.
Now, in cases when all the components are connected together by use of bus lines, is the car navigation system localized or decentralized?
When they're connected by bus lines, then it is a localized implementation.
Now, a system which is connected by way of bus lines, can it be said to be similar to a wireless system?
Functionally, certainly.
Would the construction of the wireless and bus line connected system be the same?
Physically not, but functionally yes.
Okay. Have you perused the prosecution file wrapper related to this particular case?
To the extent that it was the extract that was made available.
Okay. Now, what is the additional voltage source that has been detailed by the plaintiff?
That is the car battery in the embodiment.
And where is the second memory means located?
That is in this embodiment, it is the RAM in the system.
And what is the location?
That is in the unit in the car.
It's in the car, right? Okay. Is it correct that the main purpose of this invention is the convenience and cost effectiveness towards users?
I believe convenience is the main objective. The cost is only mentioned for the embodiment.
The plaintiff has specifically stated that CD-ROM are extremely cost efficient. Is that correct?
Certainly they are cost efficient, but there are even more cost effective options available.
Are any other such options disclosed in the complete specification?
No, but they would be known as common general knowledge.
Now, if the components are connected by way of wireless connectivity, when such connection is interrupted, would the car navigation system or the claim method work?
If that was a single link over the wireless, then it would not function to the extent of the user making selections, but otherwise would work. But you could also have situations where there are multiple wireless links.
Mr. Bhatnagar, I have a question. So you mean to say that if while driving a car, in the case of the connection being disrupted, a fresh selection cannot be made by the driver?
Your Honor, if there is a single wireless connection which is interrupted, then the selection would not be possible at that time, but you could have multiple wireless connections.
There are certain suggestions which I would like to put to you, Mr. Bhatnagar. I put it to you that the term cloud computing or remote server does not find any mention in the complete specification.
Yes, it does not
Counsel, I'm disallowing that question because it's a matter of record. It can be seen from the specification.
Please, Your Lordship. During the course of prosecution, did the plaintiff highlight or rely upon cloud computing or decentralized remote servers?
No, not explicitly, but as I said, common general knowledge would make that available to the reader.
I put it to you that during the course of prosecution and also from the reading of the complete specification, the only inventive step which was highlighted by the plaintiff was use of additional voltage source.
Counsel, again, inventive step has to be decided by the court, not by the expert.
Please. We close our cross-examination, Your Lady.
Thank you.
I have one question for you. Mr. Anand had put a question to you that remote storage was known at that time. So why do you think the applicant of the patent never stated that in the patent specification?
Your Honor, I believe that those options would definitely be in his mind and in the mind of the reader, so they were considered obvious.
Okay. Counsel for the defendant, do you have any witness?
Your Ladyship, since we are dealing with the issue of infringement, the onus is on the plaintiff, and therefore we do not wish to lead any evidence.
Okay. Now, the evidence of the parties has been closed. Parties are directed to file their written submissions and along with any case laws and judgments that they wish to rely upon. And usually the case is adjourned for a specific date for final arguments. The written submissions are received by the court officer and are also filed in the registry. And the matter is now open to scene 3, which is the final closing arguments on behalf of both the parties. Mr. Anand, would you like to argue?
So you heard the evidence. What did the witness say? First, the term memory to a person of ordinary skill in the art is wide. It includes RAM, it includes ROM, it includes cache, it includes external memory, hard disk, pen drive, flash drive, server, cloud. Second, the person of ordinary skill in the art is familiar with data being stored on an external server or even on the cloud. And this is particularly relevant when data gets infinitely large, such as map data. Third, a server solution is less costly and far more effective in many ways. Fourth, communication means and network interfaces were both known to a person of ordinary skill in the art for interchange of data between various devices. Fifth, decentralization was becoming a global norm, and there is nothing to indicate that the device was intended by the plaintiff to be an on-board device as opposed to an off-board type. Now, what does the law say? First, the defendants have relied upon a Supreme Court decision in Bishwanath Prasad's case, which only said, read the patent specification first so that the mind can be prepared for understanding the claims. That does not say that the specification will regulate words which are commonly understood in their ordinary sense, well understood and clear in the claims. Then, what do the claims, if the defendants have copied the inventive concept in its pith and marrow, they cannot escape by virtue of not only literal infringement, but also by the doctrine of equivalence or purposive construction. And if you saw the evolution of purposive construction from Katnick versus Hill and Smith in 1982 to Improver in 1990 to Kiran Amjan in 2005 and finally Actavis versus Eli Lilly in 2017, it was meant to broaden the scope of a claim and not to narrow it. These doctrines spoke of a variant, not of changing in a material effect. When you talk of a variant, you're talking about something which is outside the literal in scope. And therefore, they were broadening doctrines, they were not narrowing doctrines. Therefore, to rely upon purposive instruction was fallacious. The use of the first and second memory means, in the language of Lord Hoffman, are figurative words. It has been argued why these two terms have been used. They are figurative words. They are what Lord Hoffman called synecdoche or metonymy. Applying to the facts now, control to the user is not one of the stated objectives of the invention. It was argued that the user has control in the defendant's, in the plaintiff's device, whereas he doesn't have so in a wireless device. But that is not that is not the inventive concept. Areas of no signal, but then no signal areas would mean that a navigation system which is linked to a GPS would otherwise not be able to work. And the witness has stated that there are always backup links which are provided, particularly in mission critical jobs or tasks. The parts have not been shown as being interconnected, but this is a method claim where the parts don't have to be shown, the steps of the method have to be shown. The wired versus wireless is very different, and therefore it is not enabled for wireless. This is so wrong, because storage of data is not the inventive concept, and for enablement is only necessary for the inventive concept, not for a immaterial particular. For example, a navigation system gets stuck onto the dashboard with a suction device. You say the suction device is not mentioned, has not been enabled. That's not the inventive concept and does not need to be enabled. Where there are two separate memories are like two files on a hard disk, which are separate. Therefore, first memory and second memory are separate. The defendants chose not to lead any evidence. No reason was advanced as to why the inventor would want to limit the scope of his invention. This is an unscrupulous copyist. He cannot escape by making unimportant
Mr. Anand,
and unsubstantial
have you filed the matching of the claims to the defendant's products as part of your exhibits?
We have done that in the note of arguments that was submitted earlier.
All right.
So here we are. The pony has done the donkey's work, but the donkey has taken everybody for a ride. Thank you.
Yes, Mr. Singh, your closing arguments.
My lord, our name may be donkey, but we have a good case. I am grateful to the witness that the plaintiff has produced, because in my respectful submission, the witness has proven my case. The witness, in the cross-examination, has made certain admissions, and I wish to rely upon that. The witness has admitted and acknowledged that the invention as disclosed in the specification is a composite wired system. Secondly, feature of navigation system is part of the claim. Third, the preferred embodiment is located inside the vehicle. 4, second memory mean is located also inside the vehicle. Next, it is connected to the car battery, and in absence of wireless connectivity, the system will not work. I say that the witness and the counsel of the plaintiff have very vociferously said that cloud computing, wireless navigation, everything was known as part of the state of the art when the inventor was writing this specification. All the more reason, therefore, that the inventor chose to exclude such navigation system as part of the specification or as part of the claim. The method of navigation was not intended to be applied to a wireless navigation system. The fact that the reference to wireless navigation system, which would have been a variant, has been excluded, it cannot now be permitted to be included, and if a defendant is using that variant, then there is no infringement. I say with great respect to your leadership that the claim construction for purposes of infringement and for purposes of invalidity is the same. It cannot be different. When this plaintiff goes to obtain a patent, he says that the prior art, which is a pedestrian navigation system, is distinguished because my invention has got a second memory mean it's a RAM which is located inside the car. But didn't he know that he can have a server and give it a power? Why he had to limit it to say that it's a system, it's a RAM which is installed in the vehicle? Where was the need for him to say so? Now, he said so that he could distinguish the prior art and get the patent. Now, having got that, can he now be permitted to say that it doesn't matter? Now, anybody who is manufacturing a navigation system based on a wireless navigation system is also included in the infringement. I would say with great respect that that is not permissible. I also rely upon the principle of claim construction, Your Ladyship, that there cannot be, and I rely upon the Supreme Court judgment of India in the Novartis versus Union of India case, where the Supreme Court said that there cannot be too wide a gap between a coverage and a disclosure. The patentee ought to have known what he is describing or what he is disclosing. And today, when he has chosen not to include the wireless navigation system for application of the inventive method, it cannot be read. I would therefore say, Lord, that there is no inclusion of wireless navigation system. This system is limited to a composite system which is wired, installed in the vehicle. It only ensures that the navigation system that is provided is convenient. I wish to also place reliance on certain judgments which I would like to briefly refer to. I rely upon the judgment of our Honorable Supreme Court, where it very clearly says, if Your Ladyship will see, it says patentee cannot claim more than he desires to the patent. What he desires in the patent was very clear in the representation that he made to the patent office for obtaining the patent. Today, he cannot be permitted to ask for more. I also rely upon the judgment of F. Hoffman La Roche versus Cipla, where the court has said that the claim must be constructed so as to give effect to the purpose of the invention. And the purpose of the invention is to provide...
So, Mr. Singh, you are invoking purposive construction to restrict the claim.
My Lord, I'm not restricting, I'm also requesting not to widen it.
Okay.
But to achieve the purpose for which the method has been invented. I also rely upon the judgment of Merck versus Glenmark of our Delhi High Court, which very clearly has said claim should not be construed too broadly to grant undue broad monopoly. So I'm not saying narrow it down, but please do not also read it very, very broad. I next rely upon the judgment, two UK judgments, which have very clearly said that the defendant should not be prevented from manufacturing a product falling outside the limitation that the patentee has agreed during the prosecution. Now, my Lord, there are two judgments on that, which is also Merck versus Generics, which I am relying upon, which says that the patentee can't be permitted to include variants that are kept out of the specification while obtaining the patent. Now, this is consistent with the rule of estoppel, prosecution estoppel. It is also consistent with the rule that a party cannot be permitted to approbate and reprobate, and if I may say with great respect, this principle is applicable to all civil disputes, which includes patent infringement case. I therefore conclude my submissions, Your Ladyship, by saying that applying a purposive construction of claim arising from reading of specification and claim together, duty of disclosure and permissible coverage based on such disclosure, prosecution history and representation distinguishing prior art, constructing, preserving validity of granted claim as a mode of preferred construction, the claim is limited to provide convenient navigation system achieved by a composite and wired system which is supported and installed inside the vehicle. Therefore, there is no infringement committed by the defendant. I'm grateful.
Mr. Anand, do you need a minute?
I wasn't aware, my lords, that I had this luxury of a rejoinder, but just one point. On the prosecution history, the patentee never said to the patent office that the embodiment which was stated in the patent document was the only embodiment. And therefore, any other embodiment which came naturally to a person of ordinary skill in the art as a part of common general knowledge was also possible, and therefore the statement made was that a sufficiently powerful battery backup is necessary to protect the RAM.
All right.
And that RAM is protected even in the defendant's D server.
Both the counsels have concluded their arguments. Their evidence has been concluded. The court reserves the judgment for pronouncement. Now we move to scene 4, where the case is listed for pronouncement of the judgment. It is shown in the cause list one day before, when the judge sends the note to the registry. This is how it comes up. Now coming to the judgment itself, the court has appreciated the submissions by the counsels and has considered all the evidence and the pleadings which have been given. So the judgment is as under. The claims in the present case clearly use broad terminology. The term means cannot be read in a restricted manner and has to be interpreted in the context of the invention. It is a fact of which judicial notice can be taken as confirmed by the expert witness that there has been a drastic change in the manner in which memory is stored and the devices used. Therefore, the devices have undergone constant progression over the years, and the physical nature of the device cannot restrict the word expression memory means. The term of a patent being 20 years, if the specification contains an example of a CD-ROM, to restrict the term memory means to a CD-ROM would be doing injustice to the invention, as the devices that can be used to store memory are extremely fluid in nature. The said means could include a large server to the smallest USB or flash drive. In 2002, the inventors could not have restricted the claims of the suit patent to a first memory and a second memory means, which were both localized, since non-localization of such data was quite prevalent at that time. The context of the invention is to provide for a constant dialogue between the primary and the secondary means for ensuring that the user does not need to perform complicated operations to find a location. The intention is not to just make it cost effective, but primarily to make the same user friendly by allowing the primary and the secondary means to seamlessly communicate with each other. The specification clearly captures the objective of the invention as user friendly without performing complicated operations for displaying service facilities on a map. Viewed from this perspective, the inventive concept of the invention resides in the method by which the primary and the secondary means communicate constantly with each other, irrespective of the location or the nature of the said memory means. The primary and the secondary means are not required to be interpreted in a narrow manner, but have to be interpreted purposively in the context of the invention and the object sought to be achieved. As per section 10(4)(c) of the Act, the claims define the scope of the invention. Section 10(4)(b) makes it clear that the patentee has to disclose the best method of performing the invention in the specification. This clearly means that the patentee at the relevant point may have thought that the best method practically feasible and cost effective would be to use a CD-ROM for the primary memory means. However, the best method cannot be the only method. The scope of the claims is beyond the best method disclosed. The claims have to be thus interpreted broadly. D-terminal has a primary and secondary memory means. Both may be remotely located and even located in the same server. The physical location does not take away the fact that the server performs the function of two memory means. The physical location of the system, except the terminal, being outside the vehicle, does not take the D-terminal outside the claims, so long as the D-terminal has the primary means, the secondary means, and the terminal. The navigation system achieves the same purpose using the same method. Coming to the relief to be granted in this case, I would like to say that the question of file wrapper estoppel, the settled position is that statements made during prosecution are less useful for claim construction. The patent office ought to have restricted the claims the court cannot read into the claims the words installed in the car. Finally, the relief. The court has considered the submissions of the parties as also the pleadings. The expert has given his evidence. The patent dates back to 2002. Only 3 years of the life of the patent are left. The court, while considering the grant of an injunction, has to keep in mind the balance of convenience and irreparable injury. In the present case, the defendant launched the system in 2013, but the suit for infringement has been filed only in 2018. In the 5-year period, the defendant has sold its navigation system to millions of users across the country. The defendant's system is infringing. However, instead of a permanent injunction, the court grants ₹5 per system which the defendant has installed as royalty to be paid to the plaintiff. The defendant is allowed to approach the Intellectual Property Appellate Board for revocation of the patent. The amount deposited by the defendant can be withdrawn by the plaintiff subject to a guarantee. If the patent is upheld by the board, the guarantee is discharged. If not, the plaintiff would have to refund it with 6% interest. With this, the suit is decreed in the above terms. Thank you.
インドの皆様方、ありがとうございました。以上でインドの模擬裁判を終了とさせていただきます。ここで20分ほど休憩を取ります。15時50分より再開いたしますので、それまでに席にお戻りください。Now we will take a 20-minute break. The next session will resume at 3:50 p.m. Please return to your seats by then. パネルディスカッションで使用するスライドは日本語および英語におきまして知財高裁ホームページでご覧いただけます。 QR コードは講演資料の表紙の裏にございます。再開時刻は15時50分です。